No.
The decision in Germany was February 26th, 2015. The building commissioner affirmed the ZBA on March 3rd, 2011. They actually filed their appeal in August of 2010. It was denied by Eladio Gore on September 24th. And the ZBA, by that 3-1 vote, affirmed Mr. Gore on March 3rd, 2011.
So does anybody want to speak about latches? Does anybody have any thoughts on this? I mean, I have thoughts, but.
I gave the board all the decisions
Right.
for all of the wind turbine actions brought forth by Drummy, Anderson, Okagawa, where Wind 1 and Wind 2 were both mentioned through the years. So you should all have that information.
Does anybody want to start the discussion?
No.
Okay. I think, Ed?
Good, no, he's the good lawyers.
I mean, I'm happy to start it, I guess.
Yeah, I'd like to hear it.
I'm sorry, I have my back. So I think that, I mean, I buy into the doctrinal latches. I buy that they knew that there were, you know, it has a different effect, and that's something that, you know, they argue on one hand to have standing, that this Wind 2 has a different effect on different people. Some people the same, but definitely has an effect on them. And I think even if you say, okay, so they didn't know within the 30 days, they didn't have constructive notice within those 30 days, they didn't have a duty to inquire. Lisa as to Okagawa, she knew in October 2010, that was clear. So even if you say, all right, she doesn't know about the building permit for 1.5 years, but once that starts operating and she knows of its effect, then you start to question, well, you know, she knows of the effect, so maybe she should bring the appeal. She retained Attorney Senni, I think my notes say late 2013. Still, no appeal was brought, and obviously council knows that if there's, you know, you could seek an enforcement action, and I credit Attorney Senni because he said, well, maybe this was my slip up. He did say that, and certainly that takes a lot to acknowledge, and you know, I just think on the information that's before us, they certainly did, you know, wait until the Wind 1 special permit decision. And, you know, maybe there's some justification on a personal level. They don't want to incur legal fees or costs. But I also think, you know, Attorney Tilson's point, well, they could have combined these appeals. You know, and then we have an order right now that a special permit's required for Wind 2. And I think the fact that you can combine appeals is present just by virtue of this action. We're considering we were considering three appeals at one time. So, and certainly empathize, and I think Wind 2 needs a special permit. I no doubt, I think that they need a special permit, and I think that the town has an obligation, certainly if we talk about good faith, to apply for that special permit. But on the basis of this, whether or not the cease and desist appeal can be maintained, I think that they waited too long. Reading through the cases, it says stuff about, you know, 8 months was too long. That was the Allison, I know it's a land court decision, but he said, certainly under these circumstances, 8 months is too long. And that was a seasonal residence. There was some evidence that the people who lived next door were only there seasonally. They didn't necessarily know about where the building was. These are impacts that we've heard affected them every day, and yet an appeal wasn't brought. And I know, you know, Eladio Gore, there's some discussion, well, you know, he didn't, he said, don't bring, you know, I'm not gonna do anything about your complaints. But wing 2 is separate from wing 1, and if Eladio Gore didn't do anything, they could have, you know, flooded him with written letters, and if he failed to act, they could have appealed that to us. So, certainly, you know, the burden to some extent is on them, and certainly the town's not, I wanna say not an innocent actor, I think, you know, if they need a special permit, they need a special permit, but at the same time, it wasn't the town's obligation to say, just like it wouldn't be any property owner's obligation to say, raise their hands and say, well, ooh, I need permitting. If the people who are affected by it aren't doing anything affirmative. So that's my read of the case as.
Well, remember, this has two parts. Was that a reasonable or an unreasonable delay? And secondly, was there a showing that there was some sort of, be sure I give you the correct words from the Myers case. To establish the defense, there must be proof that the delay worked some prejudice or disadvantage to the defendant. That would be the town. So you have to have that too.
So it sort of seems like piling on to me. That's really what it was. Wait until we get the decision from the SJC and then pile on.
And I would just say I guess to the last point, to establish the defense, there must be proof that the delay worked some prejudice or disadvantage to the defendant. And maybe this speaks to what you're saying, piling on. That was something that I struggled with. I said, well, what's the harm here? But I definitely appreciate, I know Attorney Tilson made some points about that, but I thought the point, so now they appeal win 2. Now it starts exactly where win 1 was years ago. And I think given, the complexity of this, and I do think that that's a real harm to the town, that they're significantly staggered appeals. So that I do buy that, and I maybe they would have done things differently depending on when that appeal win 2 came on.
Yeah, it's a long time. It's a long time.
It's almost at the, we're approaching the end.
Yeah.
Really, the end of the 6-year period. TJ, do you have any thoughts?
It comes down to whether it's a reasonable delay. The years involved, like you said, we are coming to the end of the 6-year period. On one hand of the issue, I do realize that people don't have unlimited funds to pay attorneys and litigate all these issues, but like you said, at the same time, combining the cases was possible. And, at this point in time, I feel like it might prejudice and have the town at a disadvantage at this point when it comes to latches.
Ed?
I agree with the two lawyers on this one.
Yeah, I agree, yeah, it's a long, long time to wait.
Okay.
I'm in accordance with you guys.
Okay.
So by consensus, which is 5-0, you think that latches bars the matter from going forward?
Yes, I guess we would say both matters from going forward.
Well, with regard to all three, I
Yes.
guess is the-
Yes.
Can I ask you to give me a little bit more precision with regard to the harm that you think the delay caused the town? I have the right to say. I want to be sure to capture
Sure. And
what you think. at the October 29th hearing, and it's in your minutes on page 2.
October 29th. During the file, October 29th. And you also,
I think I declined, I just that people. So what, TJ, you have them out?
I only printed last week's, because you guys did not have them.
Are you, Attorney Bobrowski, you referring to the middle section there?
Yeah,
Summer's revenue and expenses, is that?
there was this was all, I believe, taken from Diane's PowerPoint. Diane told us it's PowerPoint. Should I simply go back to the PowerPoint and refer to it in terms of the economic harm that resulted from the delay, or?
Well, I think that's multi-layered. I guess the economic harm, certainly. The harm that, you know, the town, I guess for lack of a better word, I don't defend it, but that there was already an appeal on the basis of similar harms that they could have conceivably, I guess, consolidated and been considered at the same time by the courts. And so that it is an undue burden and harm and prejudicial to the town to have to go and relitigate those same issues. And I know Attorney Tilson also said that they, I guess, I don't know if it was the timing there was some statement that they had entered into contracts, and I apologize, my notes aren't perfect, but, and that they, you know, it's difficult to tell us right now because we're second guessing what decisions they would have made differently. And I think given, you know, certainly the public impacts of these projects, or the 2 wind turbines, certainly they may have proceeded differently. And I think the financials, you know, the legal appeals, I do think that it would be prejudicial and that there would be harm to the town. If I'm missing anything, I did.
It's spelled out in Julia's October 16th letter.
Yes.
The question is harm to the town?
Yes.
More protracted litigation, which
Okay, what I'll do is I'll try to capture that by going back through those materials. Your meeting on the 10th, we have until the 23rd. I would like you to have a look at what I write before making a final vote on it. What we've been doing is mostly by consensus this evening. So I want you to pay particular attention to that portion of what I try to put on paper and have a vote to accept the language. And if that's the case, that will be your official vote in this matter. If you want me to tweak anything, we'll have another 13 days to do it. I won't be here on the 10th, so you'll need to be specific with me about what it is that you want tweaked, and I'll rely on the chair and so you get me that information.
is, there's one issue that is in my notes, which is that the building commissioner's own letters, which counsel for delay awaiting court decision. How do we,
It's 1-1.
okay. But that was delay with respect to, I have to remember, my notes say, check this out.
And he never did.
If I did, I've forgotten what I discovered. Was that delay with regard to a response to an inquiry about Wing 2, pending the decision on Wing 1? Or was it?
Well, even if it was a response to Win 2, right, and he said, well, I'm not gonna consider this, right? But they're saying it's a separate harm. And a lot of your boards refusing to take action, so then you can appeal that to our board.
Definitely.
And there was no appeal of that refusal,
Okay.
right? if it was wing two.
That could be.
And we don't know if it was if it was separated like that.
Mm-hmm.
So let me be clear, while we're talking this through. That means that the substantive enforcement request for wing two need not be answered. If these threshold questions are not passed with flying colors, you don't get to the substantive questions. Judges don't answer questions they don't need to answer. And latches prevents us from getting to the payday of the open